Hey everyone, this is Laura. I just wanted to give people a quick introduction to the federal rules of evidence and objections if this is something that you're not very comfortable with or familiar with coming into mock trial. So let's get started. Okay, so beginning with kind of what are the federal rules of evidence? What are rules of evidence? So rules of evidence are basically the rules of the game. So just like in soccer, you have rules that kind of dictate how the game is played. And if one of the players breaks one of those rules, then the referee intervenes, stops the misconduct. That is kind of the function that the rules of evidence play in mock trial. Unlike in soccer and other sports though, in mock trial, if someone breaks a rule, the judge normally will not intervene without any prompting. The judge will just let the trial continue on, even if someone is breaking a rule. So if we see the other team breaking a rule, then it's up to us to call that to the judge's attention. And we do that by objecting. So when someone objects, what will happen is the judge will listen first to the lawyer who's making the objection, and they'll listen to the argument about what's being broken, what rule is being broken, and why the opposing team should not get to break the rule. And then the judge will let the other team respond. And this conversation between the judges and the two lawyers will go back and forth as long as the judge allows. Once the judge is satisfied that she's heard everything that she needs to make a decision, she will tell both lawyers how she wants to proceed, and then the trial will continue on. So getting into some of the specifics of kind of what an objection looks like. An objection happens when someone breaks a rule of evidence, or in other words, when someone says or does something that is forbidden. Or maybe more accurately, when an attorney believes that a rule of evidence is being broken. Objections, the fundamentals of an objection is that if you see something that you believe is against the rules of evidence, you don't need any prompting from anyone. You just stand up, you say, "Objection, Your Honor," and then normally you explain why you believe the rule has been broken. So it could sound something like, "Objection, Your Honor, this is hearsay," or "Objection, Your Honor, under 402, this is irrelevant." You'll notice that sometimes attorneys use the number of the rule of evidence, and sometimes they only use the title of the rule of evidence. That's really a stylistic choice, although it's good to know both of them. Objections can be made at any time during a trial. They can be made during direct examinations, cross-examinations, and statements. There is some debate on the Harvard mock trial team about whether it's appropriate to object in the middle of an opposing team's statement, their opening or closing. But regardless of where you kind of fall in that debate, and I would listen to your captain if you're unsure, regardless of where you fall, it absolutely is appropriate at the very least to object at the end of the statement after it's finished and say something along the lines of, "Your Honor, in the past I've said, Your Honor, out of respect for blah, 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 I did not object during their statement, but if I had, I would have objected to X." And I've got feedback going both ways saying you should have objected during the statement or it was good of you to wait. So kind of a stylistic choice there. Some things that are really important to keep in mind are that after the initial objection is made, which again, you can make without any prompting from the judge or from anyone, after that initial objection is made and the initial argument is made as to why this is impermissible, then from there on out, it's very important to let the judge give you permission before you say anything. So after that initial response, it's important to ask, "Your Honor, may I respond?" So if you're making the initial argument, you would say your piece and then you would be quiet. And then the opposing counsel will say, "Your Honor, may I respond?" And the judge will either say yes or no. Once the other side finishes their response, then you in turn can respond to what they've said by saying, "Your Honor, may I respond?" And the judge will say yes or no. But it's important not to just begin talking. You have to defer to the judge. The other important, and on that point, judges vary widely in how many responses they'll allow. Some judges expressly state at the beginning of the trial that they don't want what are called speaking objections, which means they don't want you to explain your argument at all. All they want to hear from you is objection, hearsay, and then they want you to be quiet. And sometimes they'll just rule based on that. They won't allow any back and forth at all. Some judges are the extreme opposite of the spectrum, and they want you to explain, and they want the other side to respond, and they want you to respond, and then they want the other side to respond, and they'll let you go back and forth for quite a while. So it's all about just tailoring your demeanor and your style to what the judge is asking for. The other important thing to keep in mind is that you are never speaking directly to the opposing counsel. You're always speaking to the judge, even if you're responding to something the opposing counsel has said. So, for example, if you were objecting, it would be proper to say, Your Honor, opposing counsel's interpretation of Rule 404 is incorrect. The correct interpretation is XYZ. It would not be appropriate to say something like, Ms. Bach, that's not right. The right interpretation of 404 is blah, blah, blah. And the difference in those two isn't necessarily my tone. It's that you never want to address opposing counsel directly. You always want to address the judge. Okay, so talking about the federal rules of evidence specifically. So the federal rules of evidence are the rules of evidence that are used in trial courts. So if you're new to law school like I was and you've no real familiarity with this, like I didn't, trials can happen either in states' jurisdictions or in federal jurisdictions. And we're not going to get into why a trial might take place in a state jurisdiction or a federal jurisdiction. You will learn that in civil procedure if you haven't already. But the important thing to know is that in state jurisdictions, the rules of evidence can change from state to state. So Texas might have different rules of evidence about what can come in than California would. But the federal rules of evidence are uniform across the entire country. So because mock trial takes place with schools from all over the nation, every mock trial tournament uses the federal rules of evidence specifically. So no matter what mock trial tournament you go to, no matter where it is in the country, everyone will be using the same rules of evidence, which are the federal rules of evidence. And many state rules of evidence do track the federal rules of evidence, but they're not always identical. So it's important that you're really making sure that you're looking at the federal rules of evidence. I will state just as a disclaimer that some judges are not aware of this. Some judges are state court judges, and that's the rules that they know. Just roll with it if that happens. Mock trial is all about improv. Again, a lot of times they're very similar, so this won't really be a problem, but you are correct that it should be the federal rules of evidence if that's what you're relying on. So where can you find the federal rules of evidence if you want to make sure you're using the right rules of the game? So you can either buy books. There are lots of books out there that are just the federal rules of evidence, or you can find them online, and I'll show you how to do that in a moment. You just literally Google, you can even just Google FRE, and then the rule number you're looking for, or you can just Google FRE, and it will almost certainly be the first result that comes up. It's Cornell University. They have put all of the rules of evidence online exactly like they're supposed to appear. I'll also show you how to read the rules of evidence. It's very simple, but it can be kind of confusing the first time you look at the rules. You'll see the text of the rule is the very first thing you see. Then there are these things called advisory notes. It's not really important for this what the advisory committee is, but it's enough to say that these notes basically explain what the text means. So they're not actually a part of the rule officially, but if you're not really sure what the rule is saying, these notes are very, very easy to read. They try to write them in really plain English, and it can give you kind of a good idea of would this rule apply in this circumstance, or what is really meant by what the text of the rule says. Okay, so now we're going to show, now I just want to show real quick how kind of you would do this if you're not familiar with it. Okay, so you'll see here, these are all of the federal rules of evidence laid out on Cornell's website. This is kind of what it looks like if you just go to the home page. You'll see that they're categorized, kind of like I'll talk about in a minute about how the federal rules of evidence are categorized. To get to this page, you can just type in law.cornell.edu/rules/FRE. It's also so easy to get here. All you need to type in is FRE, and then let's say, you can see that I've been looking these up. Let's say that we're looking for the definition of hearsay, which is FRE 801. You can just type in FRE 801, hit enter, And here we go. The very first thing that's going to come up is this law.cornell. You can click on it. And then here we go. This is the rule of hearsay. So you'll see, as I was saying, this is the title, and it has the rule number, and it has the title. And then this is a very long rule, so there's a lot of text to the rule, but you can see all of this is text. It's actually part of the rule itself. Then here we have this delineation that says notes. Everything under this is not actually a part of the rule. It's not actually the text of the rule. It's just explaining the rule and explaining the history of changes that the rule has undergone. So perhaps the most helpful thing to read in terms of understanding the rules are these notes of the advisory committee. And again, I'm not going to get into the advisory committee background, but enough to say that they kind of explain the rule and a lot of key phrases that come out of rules. So for example, in relevance, a very key phrase, we'll just do it. FRE, the definition of relevance is 401. Google FRE 401. Here it is, the very first thing, test for relevant evidence. This is nice, it's a very short rule. It's only like 4 lines long. And everything under, again, this notes is just explanatory. A big key phrase for relevant evidence is that a brick is not a wall. You'll hear that a lot in trial. And that actually comes from here. You'll see this explanatory, it's in the explanatory notes, a brick is not a wall. So that can be kind of a nice way to kind of get some understanding and some background of the rules of evidence. Okay, the last couple of points here is one of the questions can be, do I have to know every single rule of evidence? Do I have to memorize every single rule and number? The answer is no. I'll give you a list of the most important rules to know for mock trial. And I will kind of highlight, it is pretty important to be familiar with both the rule number and kind of the shorthand title of the rule. So like I was saying, 401 is the definition of relevance because the judge and opposing counsel can refer to it as either. I will say that you will pretty much pick these up just through doing mock trial. You don't necessarily need to spend a whole lot of time worrying about memorizing them. It kind of just comes with the activity. But I think that there is an expectation that you kind of have these of top of mind at some point in your mock trial career. So the big categories of the important rules to know for mock trial can be broken down into relevance, which you'll find in the 400s, witnesses, which really maybe is more accurately described as credibility and impeachment, which are in the 600s, opinions and expert testimony, which is in the 700s, hearsay, which you'll find in the 800s, and miscellaneous. There are only a couple from the 100s and 1000s, maybe also 900s. Probably you could get different answers among different mock trialers about what is important to know in the miscellaneous category. And it's my video, so these are the things that I would recommend a new mocker look at. In our evidence videos, we tried to break them down approximately to follow this. We did, not every rule got talked about in every category, so this is kind of what I would highlight looking back on it. So relevance, you've got 401, 402, 3, 4, and 6. Credibility, impeachment, 602, 8, 9, 13, and 15. Witnesses, which is going to talk about opinions and specifically expert testimony, 701, 2, 3, 4, and 5. Hearsay is a really important one, and you pretty much need to know all the 800s, but especially 801, 2, 3, 4, and 5. And my miscellaneous recommendations would be 104, 106, and 1002. But again, probably different mock trialers could have different opinions on that. So I would just recommend kind of asking your captain or other senior members what their recommendations are. So hopefully in the evidence videos that you have following this on our YouTube channel, you can go through each of these categories and hear a Harvard mock trial person explain each of these rules of evidence and how they work together with the other ones. And with that being said, good luck.